I'm attorney Phil Giacino, and this is WLINY's Finding Common Ground here on Altice. This show can be seen on Saturdays, channel 115, 10 a.m., and also for your insomniacs, Thursday morning, 1 a.m. on channel 20. You can also see Finding Common Ground, another version of the show, sometimes a little more with politics, social commentary with an edge, I call it. That can be seen every Friday night, 8 p.m. on Facebook Live. You can also catch it later by going to WLINY Internet Radio on YouTube as well. Got a great show planned for tonight. We have 3 segments. The first segment is equitable distribution in a divorce action. Very interesting. Even if you're not going through a divorce, it's a very interesting topic, how it talks about the different classifications, valuation of an asset, the distribution of the asset, so worth a watch. Second segment is frequently asked questions. Along my travels, I get asked questions and I put them down in writing and we answer some of them tonight. Covers matrimonial, family court, personal injury, wills and estates. And the last topic is a thing I call American exceptionalism. The topic tonight is Harriet Tubman. So let's get to it. Equitable distribution in a divorce action has a 3-part process that the court has to consider. The first one is what they call classification. Is it a marital asset or is it a separate property asset? And that's not discretionary. That's based on facts and law. The second one is what they call valuation. What is the asset worth? You need to know that before you can divvy it up. The third step in the process is distribution, how the judge divvies it up. Now, of course, if you settle your divorce action, we don't have to go through this 3-step process. If you both agree the house will be sold and you're going to split it equally, or the husband is going to buy the wife out and give her $100,000, that's fine, you can do that. But when you can't, this is what the court has to consider. Classification, valuation, distribution. Let's get to classification. First step for a court to decide is it a marital asset, meaning it's subject to equitable distribution, or is it a separate property asset? If it's separate property, it belongs to one of the parties exclusively. In other words, if they come into the marriage with an asset and that's deemed separate property, that does not get divvied up in a divorce. If the parties buy a house with marital funds during the marriage, that gets divvied up because that's considered marital property. And that is not subject to discretion. Right? Now, the questions the court has to ask is, when did that asset, when was it acquired? And when I say acquired, it could be purchased. It could be a lottery, a ticket that has winnings, where the parties win $1 million. That's during the marriage. That's considered marital. It could be a gift from a third party. It could be a gift from the parents to both parties. That's considered marital. Okay? The next thing is, what are the source of the funds used? So if it's purchased during the marriage, is generally a presumption that it's marital. But it doesn't have to be. I'll give you an example. Let's say a woman comes into the marriage with a house and doesn't put the husband's name on it, and then they get divorced down the road. Is that marital or separate? That's clearly separate, as long as she didn't put his name on the deed. Now, the question is, what if the woman now bought the house during the marriage? That's a little more complicated, because is it marital? The presumption is it's marital. However, if she can show that she used separate property funds, it's called tracing. So she had $300,000 in the bank before she got married. She marries this man, and then she buys a house down the road with those funds, not marital. That would not be considered a marital asset. That's a separate property asset. Now, the husband might get a credit for appreciation, but that's another part of the analysis. What kinds of things are considered marital, and what kinds of things are not? An inheritance. It can be marital, and it can be considered separate. Generally speaking, an inheritance is separate property. So let's say a couple is married and the husband's mother passes away. And in the will, it says, I leave to my son $100,000. That is separate property, as long as he doesn't commingle it, meaning putting it in a separate, a joint account. As long as he doesn't do that, it remains separate property. What if that same mother said, upon my death, I leave to my son and his wife $100,000? Then it's marital. What about a third-party gift? Let's say the mother during her lifetime writes a check to the son and say, son, as a gift for being a great son, I give you $100,000. That's a third-party gift. That would be considered separate because it was given only to the son. If the check, and a lot of times you see this in a real estate deal where the parents give the down payment to the couple, and if they're not careful and they say a gift to the both of you, if they're going through a divorce, the son does not get a separate property claim because it wasn't just given to him, it was given to the both of them. What about a personal injury award? Someone is involved in a motor vehicle accident, let's say. Wife gets hit is in a car accident, and she wins $300,000 for her injuries. As long as the husband was not a plaintiff to the action, that money is all hers. If the husband was a plaintiff, so sometimes you see loss of services where the wife files a lawsuit and she's the plaintiff, and her attorney says, you know what, we can probably get more money if we include your husband as a separate cause of action for loss of services. You can do that. In that case, he would get about 10 to 15% of the overall settlement. The next one is appreciation. Now, if it's a marital asset, it's a marital asset. So if it goes up in value, the parties split that appreciation. What if it's deemed separate property? So in the example, man owns a house, gets married, comes into the marriage with a house. Wife's name's not on the house. No marital funds are used to purchase that house. Then you have to do the following analysis. Did the house go up in value during the time that they were married? And did the wife have something to do with it? Right. If it just went up because of appreciation, then in all likelihood, market forces, I should say. In other words, real estate goes up. But during the marriage, let's say marital funds were used to put a new roof on the house, to build a new room to the house, to make significant improvements to the house where marital funds were used, like a pool, air conditioning, a whole new air conditioning unit, could be from marital funds. Then the wife may be entitled to a credit, not necessarily half the value of the house or even a quarter of the value, but a credit. She would have to show that the house went up in value and something that they did as a couple, increased the value of that piece of property. If it's just passive appreciation, then the answer is no. So let's say the couple gets married and the husband has a stock fund worth $100,000. And during the marriage, that stock fund goes up to $1 million. And it went up because of market forces. It wasn't anything that he did or she did. It wasn't as if he was a day trader, or together they would come together and say, what stocks should we buy? What should we do to increase the value of that account? Let's assume it just sat there. The wife would not be entitled to any portion of that. Then we get to transmutation, which is an issue sometimes that's not really understood. And I'll give you an example why I say that. Transmutation is when one party that owns an asset, a separate property, like a house, transmutes the property to marital property by putting the other spouse's name on the deed. So let's say a couple gets married and the wife has a house from a prior marriage, and that house is hers. And upon their marriage, the wife puts the husband's name on it. Doesn't consult with an attorney, just puts his name on the house. And let's say 5 years down the road, they get divorced. She can't say, he doesn't get any part of that house. That's a separate piece of property. She's wrong. She transmuted it by putting her husband's name on the deed. But that's not the end of the story. Does she get 50% of that asset? Does he get 50% of the asset? The answer is no. You need two values. You need a value as to what was the value of the house, including the equity. In other words, if there was fair market value minus mortgage, that's the equity. That's the value of that house. You have to determine the value of the house the day the husband went on that deed. So let's say when that happened, the house had $200,000 of equity. And then the husband's name went on it, and the house went up to a value of $400,000. The wife doesn't get $200,000. The husband doesn't get $200,000. The wife gets a separate property claim for $200,000 because that was her value at the time she transmuted the property. Then the house went up $200,000 in value. The husband and wife would split that $200,000 So the husband would walk away with 100, the wife would walk away with 200 plus the 100 for a total of $300,000. That's called transmuting. Now the reason why I say that's not always well understood is because some years ago, a man came to see me and he had another attorney from Nassau County, Suffolk County case. And he said, it was a house in Dix Hills, and he said, my attorney says I made it a marital piece of property by putting her name on it, and I have to share the appreciation or what the house is worth. And the house was worth maybe $700,000, $800,000 when it had been originally worth about $400,000 when it was transmuted. So I said to him, you need two values. He said, well, my attorney only got a value of what the house is worth now. I said, well, that's not going to cut it, because if you don't prove your value or your interest in that piece of property and the value of your interest at the time it was transmuted, the judge is not going to give you any credit for that. The burden is on you. With that, he fired his other attorney, he hired me. We got another value from the same company that did the appraisal as to what it is now, went back and said it was worth X amount of dollars on the day that it was transmuted, because we know that day. You look at the deed. I saved him about $400,000 because his attorney for some reason, wasn't considering the transmutation of that property. He was looking at it, okay, it was transmuted and it's all marital now. Get two values, you can get a credit for that. That's very, very important. Now, when we talk about the three-part process, we also have to talk about legal presumptions. There's a legal presumption that property acquired during the marriage is marital. Just like there's a presumption that a child born during the marriage is the child of both parents, even though it might not be the case, it might not be the father. It's rebuttable. So you could take a DNA test, and if he's not the father, he won't be responsible for that child. It's a rebuttable presumption. The same thing with property acquired during the marriage. It starts out, for argument's sake, as a piece of marital property, and the burden is on the person saying it's separate to come forward and say, not so fast. Yes, we bought that house during the marriage, but I used monies from a stock fund to buy it. Or I get a partial credit because the down payment came from an account that I had prior to the marriage. That's all important. That has to get figured in. When a marital asset is transmuted, we just talked about that, there's a presumption that it's marital, and then the spouse that put the other spouse's name on it would come forward with two values and say, I get a credit for X amount of dollars. Again, the burden is on the person claiming separate property. Now let's talk a little bit about appreciation, which we touched on a little while ago. If you want to say, I get some of that asset, some of the value in that asset, even though it's not a marital piece of property because it went up in value, this is what you must prove, that the asset did in fact increase in value. So if you buy a house that's worth $500,000, let's say you come into the marriage and your spouse had a house worth $500,000, and you put monies into the house to improve it, and then you're going through a divorce. If the house is still worth $500,000, you're not going to get anything because the house did not increase in value. That's the first step. Second one is the non-title spouse has to prove that they did something directly. That's the first part of the first prong, that they did something directly, like marital funds being used. Or let's say it's a business. Let's say the husband has a business and the wife is the bookkeeper, or she's in the sales force. She's doing something to benefit that business, right? She could share in the appreciation. The title spouse, you should have to show, contributed also, not just passive appreciation. So if an asset went up just because market forces, no, you don't get anything. The next one is the non-title spouse contributed indirectly. Remember I said they have to show directly? Well, they can also show indirectly, and that they did other things. Maybe they weren't the bookkeeper. Maybe they weren't in the sales force, but they did other things that contributed to the success. I'll give you an example. Let's say the husband has a business and he's working 12 hours a day. The wife is home taking care of the kids and taking care of the household and maybe having an occasional cocktail party for people at the company or potential investors, let's say. She could show he wouldn't have been able to work 12 hours a day and do everything he did but for the fact that the wife was at home taking care of the kids, taking care of the household. Right? So she can show it. Directly is stronger, like I was a bookkeeper. That's going to carry more weight. But if you can show indirectly, you might have something there. Like I'll give you an example. Let's say they didn't have any kids and the wife just sat at home and did nothing. She probably wouldn't be able to show non-monetary contributions. All right? That there's a nexus between the non-title spouse contributing and the appreciation. Again, that it wasn't passive. It was something they did. The business went up in value. Or they made improvements to the house went up in value. All right? And the non-title spouse is not required to quantify the extent of their contribution. So if they were the bookkeeper, they won't be able to say, I contributed $100,000 worth of my time. They don't have to do that. They did something that benefited. Now that doesn't mean they get 50% of that company. They don't. They might get 10%, 15%, some lesser amount, unless they were a partner, or unless it came about they started it together. The next thing is valuation. Remember I said it was classification, valuation, distribution. The next part of the process is to determine what is the value of the asset. How much is it worth? Because if you don't know how much it's worth, how can a judge divvy it up? Now, he could say 50-50 and leave it at that, but you need to know the valuation of the asset if you're going to divvy it up in some way. How do you do that? You hire a company that does an appraisal, let's say. Now, sometimes people do it a little cheaper or for free. You can get a market analysis where you go to a real estate company and you say, I'm thinking about selling my house. What is it worth? And they give you a little report and they say, we think it's worth 300. And if both parties agree, you can use that 300. If the parties don't agree, the court might say, I'm going to appoint Given and Associates. It's a company that I use. That company will go for a fee, $500-600, and will write a report as to what the value of the house is compared to other houses in the neighborhood or the area, and say, this house is worth X amount of dollars. Usually, the parties are stuck with that value. Or each party hires an appraiser, and then it's a battle of the experts if the case goes to trial. Usually it's better to get somebody you both trust. They come back, you pay one fee, and you don't have to litigate the issue. I've had cases where I had to actually litigate. We had one appraisal, they had one appraisal. There were reasons for that. Now, what are some of the assets that would have to be valued? A house, obviously. You can do an appraisal. But there are other things that are less obvious, like a pension, like a 401k, like an annuity. So the house, you go to a real estate company like Given, or you go to Century 21, that's how you do that. A little more complicated to do a pension, let's say. Because even with a 401k, you get a statement. And you could say, okay, there's 100 grand in there. It was started when they got married, it was only 40. So you can calculate what the appreciation was that the party will share in. But with a pension, it's a little more complicated. So you can hire a company like Crockett's Quadros or Lexington, and they will crunch the numbers and tell you the marital portion of the pension is $100,000. So you know that it's 50-50 each, pretty much. Although when we get to distribution, you'll see it's not always that way. But with a pension, unlike a house, with a pension and a 401k, things like that, there's a thing called the Majaskis formula. There's a numerator denominator, and it calculates the marital portion. I'll give you an example. Let's say a man is a cop, and he started in 1990, and he married in 2000, and the divorce is in 2010. So the filing was 2010. And let's say now we're in 2012. The divorce dragged on for a while. He gets his separate property claim from 1990 to 2000. Wife can't touch that. Then from 2000 to 2010, the date of filing, that would be considered marital. And then 2010 to 2012, that wouldn't be marital. That would be his separate property. So the company would calculate. No attorney in his right mind would calculate this. I'm a finance major and took many accounting classes. I wouldn't endeavor to figure out what the marital portion of a pension is. We leave that to the professionals. Any more than a client comes in and says, I got a bad cough. I'm not going to tell them what to do. I'm going to stick to the law and we leave things like that for the experts. Just like the same as a house. I might say, that house is probably worth $400,000. But we're going to hire a professional because in court, they're not going to say, well, Attorney Giacino says it's 400, so it must be. We use an expert. Now, when you're dealing with pensions and 401ks, things like that are considered retirement accounts, unlike a bank account or a brokerage account, you need a quadro. Sometimes you can do a rollover, like maybe with an IRA, but there are certain accounts where you need a quadro. A quadro is a qualified domestic relations order. It starts out as a DRO, domestic relations order, and the judge signs it. That becomes a quadro, and that allows the non-title spouse to get a portion, their marital portion of that pension. Right? Almost like they work for that company, and they're going to get the pension when the husband or wife, whatever the case may be, retires. Right? So that's what it is. Because even if the husband said, you know what, instead of getting divorced, I'll give you half my pension. He can't do that. You need the quadro. And you got to get a quadro in Supreme Court. You can do many things in family court, custody, maintenance, child support, things like that. You cannot do a quadro in family court. It has to go to Supreme. And it's also important to stay on top of it because often the case is settled and you say, okay, we're going to do a quadro. And if it's not done, then the non-title spouse never gets what they're entitled to. And you want to do that kind of soon because if the other party gets married, it could really mess things up. Because then the quadro is never done. Then what if he goes through a second divorce? And then there's still the pension intact. So you want to try to get that done as soon as you can. There are additional fees involved, but you want to get that done as soon as you can. Other assets that need to be valued, which are pretty obvious, you could have a coin collection. You could have a doll collection. How do you do that? You don't always need an expert. Sometimes you do. I'll give you an example, a car. Let's say you have a 2018 Honda. Right? You go to Kelley Blue Book and it'll tell you pretty much what the car is worth. You put in how many miles, you even put in the color, you put in the condition. Is it poor, fair, good, excellent? And it spits out the car is worth X amount of dollars. I used those two things yesterday, as a matter of fact, to help me settle a case. We knew what the wife's car is worth, which was more than his. He gets a credit. So let's say her car is worth $10,000 and his car is worth $5,000. That's $15,000 total of that asset. So each party should be walking away with $7,500 worth of those cars. So she keeps her car, he keeps his car, but his car is only worth $5,000. So she would write him a check for $2,500 to make it $75,000, or give him a credit off of some other asset. Baseball collection, doll collection. I remember one time I had to hire an expert to come to my parking lot to value. It wasn't an antique, it was like a souped up muscle car. And Kelley, it wouldn't really do it any justice to go to Kelley Blue Book because the car was modified. So an expert came and said, okay, that car is worth this. He takes into consideration, when a car is redone, was it done the right way? Was shortcuts taken? An expert will tell us what the car is worth. I have no idea. And Kelley Blue Book probably wouldn't tell you what the car is worth. Now, just like with classification, it's not discretionary. It's either marital or not marital. With regard to valuation, it's not discretionary. The judge has to go by the facts as presented. So if the expert testifies that the house is worth $400,000 and he believes that expert, he can't say, the judge can't say, well, you know what, I think in this market maybe I'm going to say the house is worth $350,000. No, they're not supposed to do that. The expert said $400,000. Now, if two witnesses testify, and one is $400,000 and one is $350,000, they're supposed to see who they believe. Now, sometimes they might say, let's split the difference and do $375,000, but they're really supposed to go with the expert that they believe is more credible. And a court can order an asset sold only after the case is resolved. So let's say the parties file a motion, pendente lite motion, meaning pending the litigation, the wife wants custody, maintenance, child support. The court can order that. The court can't order interim, on an interim basis, the house be sold. They can't do that. The parties can agree to do that, but the judge cannot do that. That comes after a final determination, like at a trial. There's a trial, the judge says, I'm going to sell that house. Right? Now, the court can also order that a party gets exclusive use and occupancy of that house. So let's say the wife is going to get custody of 3 kids. The court could say, The divorce is going to go forward, and the wife is going to have exclusive use and occupancy of this house for a period of time. Husband's going to get an apartment. A lot of times it's when the last child graduates high school. So let's say there's a divorce and there are kids in 10th and 11th grade, and the parties can afford to keep that house. The judge is probably going to say, I don't want the house sold, because if it gets sold, these kids may have to go to a different high school, and they don't want that. Now, if there are no kids involved, it's easy. Sell it or divvy it up in some way as you agree. If you don't agree, it's being sold. I'm not going to waste time going back and forth with you two. I'm selling the house. That's what the judge would say, unless the parties agree otherwise. So if the court granted exclusive use and occupancy, there would be certain things put in the order, or if there was an agreement that said that. In other words, if the wife missed 2 payments, mortgage payments, the house may have to be sold because it's going to hurt the husband's credit. Or that she has to pay the mortgage on her own with maybe maintenance and child support she receives. So that's only, like if the parties are on the balls of the you-know-what, the court's not going to say, yeah, the wife can stay in the house. A lot of times they'll say, you got to sell it. Now, the parties want to keep her in the house until the house is lost through foreclosure. A lot of times the judge is not going to interfere. He's going to say, that's your business. The last phase of that test, remember, it's a 3-pronged test. First, classification, valuation, distribution. The last part of that is distribution. That's discretionary. First 2 aren't. And what does the court consider when they're going to make a determination on who gets what? Generally speaking, as a practical matter, and I've been doing this almost 30 years, most of the time the court is going to do it 50-50. So if the house has equity of $500,000 and the judge is going to divvy that up, let's say it's not going to be sold, but the judge is going to divvy it up in some way, the judge will say 50% to the husband, 50% to the wife. Or after it's sold, the proceeds will be split 50-50. Or 50% of the marital portion of that pension. The court can deviate. This is the discretionary phase. Give you some of the things that they consider. It's found in Domestic Relations Law, Section 236b-5. One of them is the income and property of the respective parties. So I'll give you an example. Let's say the husband is a brain surgeon and he makes a ton of money and the wife doesn't work. She doesn't make any money. And once they're divorced, he's going to go on and make $1 zillion and she's not really going to do that well financially. The court can say, because of that, granted she'd get maintenance and other things, but the court could say, I'm going to give her the house. Or I'm going to give her 70% of the house or 70% of some other asset. Another thing the court can consider is the length of the marriage. The longer the marriage, the more likely it is to be 50-50. Short duration marriage, it might not be 50-50. The age and health of the parties, like I said, if he's a brain surgeon. But what if he's 35 and the wife is 65 and she's not going to be able to go out and get a job and he's in his prime earning years? The court can look at that and say, she's older and more infirm. I had a case similar to that today, where I was able to use those factors to get my client a bigger piece of the pie. They also look at present and future earning capacity. It kind of goes hand in hand with income and future prospects of the parties. The need for one party to incur education. So let's say the wife is going to have to work for a number of years to get an education, to be able to get a job where the husband already has his doctorate. She could get a bigger piece of the marital estate. Also bad acts, domestic violence, or maybe the wife did something to hurt the husband's prospects. Let's say she lied about him and said he did something that he didn't do and he lost his job. Well, that could be a factor. A couple other ones as we're running out of time. Exceptional expenses. Let's say the wife's on dialysis and she has expenses that the husband might not have. She can get a bigger piece of the pie. Tax consequences. Is what he's getting liquid and she's going to get something that's going to have to be paid, taxes be paid on it. That's a factor. So very important when you're going through a divorce that you have an attorney that can understand all the intricacies, especially equitable distribution. It's not like a divorce, it's best interest of the child and you do battle who's the better parent. Here, there's a process that has to be followed. Classification, valuation, distribution. Only until the attorney who's handling the case understands those fully will he be able to say this is what you're entitled to and advise you properly. So stick around. We have segment 2 coming up, which is frequently asked questions, followed by Harriet Tubman, who was an exceptional finding common ground here on Altice. This segment is called Frequently Asked Questions. Let's get right to it. What do I do if I need child support? People ask me that question all the time. If you have an arrangement with your spouse or the other parent of your child, you can work out a deal where they pay you a certain amount of money for child support, for the extras, add-ons, we call add-ons. It could be medical, it could be extracurricular activities. That's fine. But if you want a court order, and I suggest you get a court order because you can enforce a court order. If you have a deal with your spouse and he at some point says, I'm not going to pay you anymore, you would then have to drag him into court and file a petition for child support. So it's always good to have that order. It has a little teeth in it. And a guy is more likely to pay something if it's a court order than if it's just a handshake. So you first file a petition. You go down to family court, or you can come to see an attorney like myself, where we would draft a petition. The petition would say that you're the parent of that child or children. You name the other parent. Now, if you're married, you don't have to do the next step, which is paternity. Because if you're married, there's a presumption that that child belongs to the husband, if you're married. If you're not married, then there's no presumption. So you'd have to do a paternity petition as well. Now you can establish that a couple of different ways. One is you go in, they do a DNA test. So the husband could, let's say the father of the child could say, I don't know if I'm the father. I want a DNA test. They do a DNA test, cheek swab, a swab of the father, the mother, and the child or children. And then it comes back about 6 weeks later. Yes, he's the father, or no, he's not. Usually it'll say 99.9, or he's not the father. If he's not the father, that's the end of it. If he's the father, then he has to pay child support. So then the question is, how much? Well, before we get to that, so the petition comes into court, they process it, then you get a phone call. You have to pick that up. If you have an attorney, I handle it for you. And then we have to serve that petition on the individual, usually 8 days prior to the court date. So let's say you filed January 5th. You get the papers back, let's say mid-January, latter part of January. You have to serve the other individual, and you have a court date in February. You go back to court, and on that day you have to bring with you your finances, your child support worksheet. You have to bring your tax return. You have to bring a pay stub. That lets the court know what you make and what the other side makes. They have to do the same thing. So even if you're one receiving child support, they still need that information. It's still mostly what he makes, but for percentages, you need to know what you make. So let's say the court says he's got to pay X amount of dollars in child support, but he's going to pay 70% of uncovered, unreimbursed medical expenses. You pay 30%. How do you determine that? What is the income? Very quickly, how they determine the payor's child support obligation. That would be the person that doesn't live with the kids. So let's say dad lives with the kids and mom doesn't. Mom pays child support. How do we determine that number? It's 17% of their gross adjusted income for one child, 25 for two, 29 for three, and so on. Now, what is gross adjusted income? Gross adjusted income is the income minus FICA and Social Security. You don't take out for taxes. You don't take out for monies that are paid to the union. It's generally 0.0765. You take that number out, then you're left with the gross adjusted income. You take that number and you multiply it by 17 for one child and so on. And that's the amount. Then you divide by 12. You calculate it based on how the husband or the wife receives their income. So if the husband is the payor and he gets paid every 2 weeks, you've calculated every 2 weeks. If it's monthly, you do it monthly. Right? But that's what you do. Now, if the husband, who's the payor, doesn't pay child support, you then would file a violation petition to punish him. They could take his license. They could take his passport. They could put him in jail if they have what they call a willful violation. Next question. What is a financial net worth statement? Now, that I just mentioned a little while ago is one of the documents you need to bring to court, along with your tax return, your pay stubs, and so on. You have to bring your financial net worth statement. You get that from the court. That's usually handed to you along with the petition that you receive, if you're served. If you're the one who filed the petition, when you pick up your petition, it's going to be attached. In Suffolk County Family Court, there are basically two versions. One is 2 pages front and back. Another one is a little more lengthy. It's a preference. It depends on who the child support magistrate is. And that's another thing. You don't have a judge, you have a child support magistrate. They have the ability to hear your case when it comes to money issues. Next question. What is a quadro? A quadro is a qualified domestic relations order. If you have a pension, or your spouse has a pension, you're entitled to a portion of those monies. If it's your pension, you have an obligation to pay a portion of those monies to your spouse. And now the first half of this show, we talked about, is it marital, is it separate, valuation? That's an issue that comes into play here. Because you have to look at, if it's a pension, the company that does the quadro will determine, does the payor have a separate property claim? Meaning, was he a police officer 10 years before the marriage, so therefore that would be his 10 years of separate property. They have to determine that. Now, even if the husband wanted to give his wife half of his pension, he would still have to do a quadro. So the attorneys agree on a company. They hire that company. The company reaches out to the pension fund, does all the calculations, and says, okay, this is her portion, the marital portion based on the Majauskas formula. The judge signs a DRO, domestic relations order. It becomes a quadro, qualified domestic relations order. This cannot be done in family court. This is in Supreme Court. Once the qualified domestic relations order is signed, it gets sent to the pension fund, and they set up an account for her. Now, it doesn't mean she starts to get the money because he hasn't retired yet. If he's in pay status, she does. If not, when he retires, she gets her share, almost like she worked for that company for that period of time. No attorney in his right mind does a quadro. We hire companies to do that. Sometimes people say to me, well, look, I got this from my pension fund. Can you fill it out for me? No, the attorneys don't want to touch that because there's a lot of pitfalls and a lot of things that can go wrong, and you want a professional. You wouldn't come to your lawyer and say, look, I got a bad tooth. Can you look in my mouth? We let pension fund companies handle that. Next question. What does transmutation of an asset mean? Mentioned that in the first part of the show. Transmutation is when someone has a separate property asset, like a house, and they put their spouse's name on the deed. It transmutes it to marital property. So if you don't want your wife to have any portion of that house, don't put a name on it. If you're a woman and you get married and you don't want your husband, your new husband, to have any portion, don't put their name on it. There are exceptions down the road. You could still get some monies through appreciation, even though it might be separate, but it becomes a marital asset once you put that person's name on the deed. What is an uncontested divorce? Very simply, it's a divorce where you don't have to go to court, you don't have to beat each other up, you don't have to spend a lot of money. It's usually one attorney is hired, sometimes the other party can get an attorney. It's advisable to at least look at the agreement. An agreement is drafted, it's signed, it's called a stipulation of settlement. Both parties sign on to it in the presence of a notary. Other documents, like an affidavit, child support worksheet if there are kids involved, get submitted to court, and anywhere from 3 to 6, 7 months down the road, because there's a backlog, these parties are divorced. Never having gone to court, never having to go before a judge. Uncontested divorce. What is a contested divorce? It's the opposite. It's where the parties don't agree. If you don't agree, you're not going to have two signatures on either a separation agreement or on a stipulation of settlement. You could have one party have their attorney draft the agreement, say, here's the agreement signed. If the other party says no, you don't have a settlement. You might have to go back to the drawing board. So you may not have to beat each other up just yet, but you may have to sit down and have a four-way for negotiating a settlement. Or you may have to exchange documents back and forth where with an uncontested, you don't have to get that deep involved. Contested divorce, you end up going to court. You see a judge. A judge can sometimes help you see through some of these issues and might say, well, if this goes to trial, I'm leaning toward me doing this, or I think this is what should happen. So the attorneys get the benefit of the judge, because if you don't have a judge, each party can think they're in the right. Or one attorney might say, no, you're going to get half that house. And the other attorney might be telling his client, no, she's not going to get any part of that house because it's separate property. If you go to court, the judge might say, look, I'm looking at this as marital, or I'm looking at this as separate. You get some indication. as to what might happen if you go to trial. Next question, what is a pendente lite motion? Pendente lite motion in Latin means pending the litigation. When you file for divorce, you don't get anything immediately. It's like if you sue somebody for $1 million. It's just a piece of paper that says what you're seeking. So if the case comes into court, or you want to bring the case into court, and you want temporary child support, you want temporary maintenance, or you want temporary custody, or you want your husband out of the house, you would file, or your attorney would file, what they call a pendente lite motion. While the case is pending, the judge can decide certain issues on a temporary basis, not permanently. Eventually the case would go to trial and the judge could change things. Or the party could settle the case and the pendente lite motion goes out the window because the parties came up with another solution to that issue. In a pendente lite motion, there are certain things that a judge can't decide. In a pendente lite motion, a judge can't decide who gets the house. They can decide who stays in the house while the case is pending, but they can't make decisions of a final nature, like who gets that asset. They can't force the parties to sell the house. They can suggest it in a conference, but they can't force the parties. That's a final determination issue. Next question. If I'm taken into custody, do I have to speak to the police? You have to give the police your name and address. That's about it. You don't have to tell the police anything about the incident, why they picked you up. I wouldn't even suggest you give them your telephone. They can go through that. Don't give them permission to do that. And if you have to surrender to the police, don't even bring your phone with you, because then they might look at it and go through it. And if you don't want them to see something in your phone, don't bring it. You have the right to remain silent. If you're taken into custody, arrested, in police custodial care, you have a right to say, I want to remain silent. And they have to read you your rights. Once you're in custody or under arrest, they have to read you the Miranda warnings. You have the right to remain silent. Do that. Wait till you speak with an attorney before you say anything to the police. Now, they might try to talk you into it and say, look, come on. Even if you're innocent, just tell us what happened. This is what we think happened. Give us your version. It'll help you out. The police are not there to help you out. I'm not saying they're there to hurt you or to get you in trouble for something you didn't do, but they're there to make a case. They believe you committed a crime, and they want to get that case together, hand it off to the prosecutor who will prosecute you. Don't make their job easy. Be polite. Don't be fresh. Don't be a wise guy. Say, this is my name, this is my address. I'd like to call an attorney or a family member that can get me an attorney. Next question. We've got about 2 minutes left. How long is probation? Very simply, probation is with 1 year, B misdemeanor is 1 year. With an A misdemeanor, it's 3 years. With a felony, it's 5 years. And with a felony with a sex offense, it can be up to 10 years of probation. Now, when someone is sentenced to probation, let's say a DWI, for 3 years, it's an unclassified misdemeanor, but that would be 3 years. They don't have to be on probation for the full 3 years. Probation can cut them short and say, all right, you did 2 years, we're going to release you. But that's up to probation. Okay? I have a few other questions. We're not going to get to that. I'm going to save that for another time. Stick around for segment 3, which is about Harriet Tubman, an abolitionist. You're going to want to stick around for that. Very interesting. Harriet Tubman. I suspect if you went out in the street and you went up to the average young person, they might not know about her. And if they heard about her, they wouldn't be able to tell you how exceptional she was. She was a remarkable woman. She was born into slavery in Maryland in 1820, 40 years before President Lincoln would become president. And after being ill, and after her slave owner died, it was 1849, she escaped slavery with 2 of her brothers. Now, before they had a chance to make it all the way up north, she wanted to go to Philadelphia. She heard that in a local newspaper, the Cambridge Democrat, that there was a reward for the return of her and her 2 brothers, $300 a person. It was a lot of money. $300 today is nothing to sneeze at. You can just imagine what that was in 1849. A lot of money. And she didn't want to see anything bad happen to her brothers or her family, so she returned, basically dropped them off, and she left, and she made her way to Philadelphia. Now, When she made it to Philadelphia, at that time, that was before the Fugitive Slave Act, this was 1849, she could have stayed there and lived the rest of her life in freedom and without taking any risks. But she decided to come back and help out other people, including family members. And she came back, she was able to bring a number of family members and other slaves to freedom up north. And that's how she got the nickname Moses. But something happened in 1850 which changed everything. Congress signed the Fugitive Slave Act, which meant that even if you made it to the north, they could capture you and bring you back to your slave owner. And the law came about because obviously people were escaping. And the Underground Railroad was something that was helping them do that. So the law was passed where they said, you know what, you escape, we're going to bring you back. So Harriet Tubman had to change her strategy, because with the Underground Railroad, originally it was just to get to the people to the north, the slaves to the north. Once they got to the north, they were free. With the Fugitive Slave Act, they wouldn't be free. So they'd always have to be in hiding. There wouldn't be a way to live. She then started to get them to go to Canada, where there was no slavery. Now, she also came in contact with Frederick Douglass. He was another famous abolitionist of the time. A very educated, very smart man. Well known, he traveled in high society, he knew presidents. And she came about knowing him because on one of her exploits, she took the slaves to his house. And he sheltered them for a period of time until they were able to find a safe passage up north. Now, during that time, now this is the 1850s with the Fugitive Slave Act, right? Slavery was in full swing. And in fact, when I did American Exceptionalism on my first show, I talked about Abraham Lincoln as an attorney. And one of his cases, he represented a slave owner. Believe it or not, he was considered the great emancipator. He represented a slave owner, and this is after the 1850s, but before he became president, where a slave owner found out where his fugitive slave was hiding out. He located that slave and he hired Lincoln to get that slave back. Now, I guess he lost a number of friends, Lincoln, because a lot of people complained about what he was doing, because they knew that he wasn't an abolitionist, but he certainly wasn't pro-slavery. But he said, I'm just following the law. And that's what he did. We could disagree with that. I hope I would have never taken such a case, but he took that case. So this is what would happen. Somebody would get captured, and there could be a hearing, and they would return that slave back to the South, back to the rightful slave owner. So that's what the Fugitive Slave Act did. Now in 1863, Abraham Lincoln signed what they call the Emancipation Proclamation. Now that had little teeth. That was mainly done to keep the French out of the war, because it was in the middle of the Civil War, right? The Civil War started around 1861, and here we are, 1863. They're in the throes of the Civil War, and Abraham Lincoln says, let me sign this proclamation. It freed the slaves in the South on paper and sent the message to any other country like France. If you get involved in this war, you're backing the South, which is for slavery. Now, how did the South take the Emancipation Proclamation? No big deal. They had the slaves. There was no enforcement. So they weren't about to turn over their slaves because Abraham Lincoln signed the Emancipation Proclamation. So that didn't help the slaves. It wasn't something that really helped Harriet Tubman in her struggle to get slaves to Canada. It wasn't until the 13th Amendment was signed by the Senate in 1864 and the House in 1865 and ratified in 1865 that slavery was ended once and for all. So prior to that, if you were captured anywhere in the country, other than, let's say, if you were out of the country in Canada, you were safe. But up until the 13th Amendment was signed, in 1865 it was ratified, slaves, no matter where they were, unless they were able to buy their freedom or work something else out, they were not free. The 13th Amendment freed slavery once and for all. Now, Harriet Tubman is exceptional because, as I said a little while ago, Once she made it north in 1849, she was free. She didn't have to do a damn thing. So even before the Fugitive Slave Act was signed, she was going back and forth with this railroad, the Underground Railroad, helping people escape. She got a lot of people out of there. I don't know what the numbers are because it wasn't like they kept records, but it was a lot of people, a lot of slaves that she freed, an exceptional woman. She risked her life because not only could she have been taken back to slavery, but she could have been whipped, she could have been killed. They knew what she was doing. It was no secret. It was like hiding in plain sight. And that's why the Underground Railroad was remarkable, because people, and white people as well, were risking their lives. Right? The white people could have done nothing and said, look, that's not my fight. I'm not going to deal with that. But they didn't. White people got involved. Free slaves got involved. They got these people to freedom. And that's a remarkable thing that this woman did. So with that, I want to end the show. I want to say thank you for watching. Again, on Saturdays at 10 a.m., channel 115, you can watch this show. Also Thursday, 1 in the morning on channel 20. And also Finding Common Ground, I do a different version, a little more livelier. I have a chat room, people call in. That's on Facebook Live and also on YouTube. Thanks for watching.